Welcome, everyone, to the Team Wealth Building Live. I'm so excited for today. This is the first Team Wealth Building community event we're doing. And the goal here is we are a community of like-minded people trying to learn how to build wealth, share experiences. I'm going to be the head coach of sorts, giving you all the information, the experiences, the 10,000 consults I've had with clients building wealth for over the last 15 years. I'm Matt Sorensen, a wealth lawyer, partner at KKOS Lawyers, also founder and CEO of Directed Trust Company and Directed IRA, where we have 15,000 plus accounts, over 1.5 billion assets invested. Today, we are talking about Elon Musk and what state should you set up your LLC or corporation. This is a critical topic. A lot of people are confused about what to do. A lot of people make bad decisions. As a lawyer for decades, over a decade now, I've seen so many mistakes and lost money, overpayment in taxes, too much administrative burden, lost privacy protection they could have otherwise had by setting up in the wrong state. So we're going to talk about it today. Now, if you haven't been following the news, what's going on with Elon Musk? I know there's always news about Elon, but this one's really interesting because it's about what state should you set up your LLC in. Elon's been out in the news because he lost $55 billion in Delaware court because he followed the age-old advice that everyone used to say, hey, you need to set up your LLC or corporation in Delaware. Lawyers have been telling people that for years. Delaware lawyers in particular, come to Delaware. Delaware is such a great state. Every big company should be established in Delaware. Every small company should be established in Delaware. Come here. We have great corporate laws. We protect owners of businesses and their management. We protect you from lawsuits and all these issues and liabilities that can arise when you run and operate a successful business. Well, we've been calling BS on that strategy for years as lawyers. We never loved Delaware. We never saw the benefits for clients going there. It's an expensive state fee-wise. So many clients are going there, yet they're doing business in another state entirely, but they've got some entities set up in Delaware. Delaware has just become an age-old place to set it up, but it's changed. Stop setting up your LLCs or corporations in Delaware. I'm going to get into Elon's case. And what we're going to do today is go over what state should you be setting up your entity in. What are some of the common questions? We've got a lot of questions that have already came in on some of my content I put out on this. I want to take some of your live questions. We're going to talk about Wyoming. When should you use Wyoming? Wyoming is a popular state, and there's some good reasons to go there. So I want to talk about when do we use Wyoming as lawyers? When do we think it makes sense? When is it overkill to use Wyoming? Should you be using Nevada or some other state like that? Should you use your own state? All right, I want to go over that. Should I just set up the entity in the state I'm at? When does that make sense? We're also going to talk about how do I move my entity? Well, what Elon Musk has already done, they've already moved their corporation. This is Tesla, by the way, a big, massive company. They've already moved it from Delaware to Texas, doing what's called articles of conversion. Some states it's called articles of domestication. I'm going to get into that, help lots of clients move their companies around from different states as they've gotten out of states that they realize they shouldn't have been into and move their entity to a state where they should have been in the first place. So that's possible too. You can keep the same entity, same tax ID, same bank account, same operating, but you move the jurisdiction or the state of formation to another state. All right. Well, let's get into Elon's case. Now, in Elon's case, what happened is he negotiated a compensation plan as CEO of Tesla. Elon owns a little over 20% of Tesla, but he doesn't have full control. Now, Tesla has a board of directors. It also has shareholders that voted on this compensation plan. In the compensation plan, Elon was able to make a significant amount of money if he met certain performance metrics for the company. Now, what happened during this time period is Tesla's value, if you own stock, from when he negotiated this compensation plan to the end point of this, went up 10x. If you had 100 grand invested in Tesla when they made this compensation plan to when the end marker was, you would own $1 million of Tesla. Now, what happened to Elon, he owns shares too, so his shares went up in value, but he also got this huge compensation incentive plan awarded to him. Now, the board of directors from Tesla approved this unanimously. The shareholders, not including Elon or any other people allied to him, his family or close allies or associates, the disinterested shareholders is what they're called, voted in favor of the compensation plan for Elon Musk, 71%. Okay. Not just a majority, they had over 70%. And that's not including Elon and all his allies, or sometimes they're called close affiliates or things like that in the voting rules. So it was approved by the shareholders, approved by the board of directors. Time goes by, the metrics are hit, Elon cashes in on the value, which was $55 billion. Well, some shareholders didn't like that. They sued Elon Musk. They took him to court in Delaware. Now, this was one of the whole reasons people said, set up your corporation or LLC in Delaware is because if you get lawsuits from shareholders against you as the owner operator, management team, significant shareholder, board, whatever it is, we are not going to let BS lawsuits come through here. We are going to kick those right out. Come to Delaware. We're business friendly. We're not going to let these lawsuits come and come back to haunt you, so to speak. So what happened is this goes to the Delaware Chancellery Court. That's the name of the court in Delaware that decides business corporation LLC cases. And the Delaware court ruled against Elon. They said, and the very first sentence of their opinion says, does the world's richest man need more compensation? I don't know what that has to do with the case. What legal reason does that have to do with the case? You can already tell the decision is not going down a legal route. It's going down some political other route. And so what ends up happening here, though, is Elon loses. He loses the $55 billion of additional compensation he had negotiated for hitting those markers. And that money essentially is going to go back to shareholders in effect, because that money is going right back to the shareholders. So now, right when this case came out, all the lawyers and the big law firms that have been saying Delaware for years, Elon Musk himself, this was a big shock. Now, Delaware itself, if Texas might be known for oil and gas, and California might be known for entertainment and technology, Delaware is known for lawyers. Like, Delaware has the highest lawyer per capita ever in amongst all the states, because it's where people incorporate and they have a whole corporation and corporation services all centered there. It is a big piece of the economy. Delaware is going to be in trouble because corporations are fleeing Delaware because they don't want to get Elon Musk like the Delaware Chancery Court did. So, all right. So this provides a good opportunity to talk about what state should Tesla have gone to in the first place? Like, where should they have established their entity, their LLC or corporation in the first place? And so there's a number of questions that came in on that on my social medias. I've been putting content about that. I want to take any of your questions live here, particularly on this topic. We can hit some other topics too as we get later into the live here. But let me hit some questions here. I've got some that already came in. And remember, I'm going to go over some of the considerations you want to have when you're setting up and choosing a state. We're going to go over moving your entity if you're in the wrong state. And we're going to go over Wyoming here in a moment. So those are the three items already scheduled to come here. All right, I'm just going to look at my team here. You let me know if there's any questions popping in yet from the live. All right, let me take some of these questions that already came in. This is from Midnight1235 on YouTube. Says, can I use a Wyoming LLC to open up a bank account in my home state? Yes. So no matter what state you set up your entity in, you can open up a bank account in your home state. So for example, let's say that I set up a Missouri LLC because I have a rental property in Kansas City, Missouri, but I live in Arizona. Well, I can go into an Arizona bank and open up a bank account with the Missouri LLC documents in Arizona. Now, there is one state that is a little chippy on this. And guess what state it is? California. What California says in general, and what they push down the throats of the banks there is, hey, if you open up a bank account in our state for an entity that's doing zero business in our state, you own a rental property in Missouri with a Missouri LLC, but you open up a bank account at a branch in California, guess what? You need to register that entity to do business in California, and you need to pay the $800 franchise tax that California has. So there's a California caveat to this, that California banks get a little bit of regulation from the state tax commission there, the franchise tax board. And so a lot of those banks are going to say, well, it has to be registered in California, particularly if you're working with a banker that is the one you walk into the branch and that's the person you get. You want to be working with a commercial banker, at least a small business banker. The retail bankers and stuff, some of them are cross-trained on business accounts, but they're not necessarily going to give you the best advice. So I'll give you a couple practical tips, though, even for some of you in California, if you're in that scenario. Work with some of the online banks. There's a lot of banks now with all the technology we have. Do you really actually need to go to the bank? And there's a number of banks we've worked with, Titan Bank, for example. They're in Texas, but they open up bank accounts for our clients nationwide. And you can go use those banks as long as you have an LLC or corporation in the state that is incorporated, whether it's Wyoming or Missouri in the example I gave. They don't care what state you live in. They're not going to make you go register it into that state. It's not necessary to do that. And so I would try using some of those resources. All right, I'm going to come back to Wyoming here in a minute, though. Midnight asked that in general, but we do have some other Wyoming questions. We do, as a law firm, and my law firm, KKOS Lawyers, we do recommend Wyoming to many clients in certain situations. And that is something that's taught out there as a strategy on when to use Wyoming. So I'm going to come back to that here in a moment. Just hang tight, because I know there's some questions already coming in on that. All right, David Garcia asks, what would you have done in Musk's situation? Well, I think if you're a shareholder of Tesla and there was a vote and it was approved that this is the compensation Musk was going to get, you should decide, do I really want to be in this company? If Musk is going to get so much compensation, Elon Musk, do I really want to be a shareholder in this? And if you had a problem with that, go invest in some other company. I think a lot of that's just my personal opinion on this. I mean, this is just preference, and I don't mean to be political on any of it. I don't think this is political, but this is my preference. Is the guy founded the company, he started the company, he's the most influential person in the company, he's revolutionized an entire industry. He negotiated the largest pay package out there. Cool, great for Elon. But I see some of the shareholders are like, but he got the largest pay compensation ever in the history of corporations too. I mean, he's created a whole new industry and category. He's totally transformed an entire industry, not to mention all the other things that Tesla could do. And in fact, Elon has talked about that. If he doesn't have control of Tesla and some of the companies, he's not going to bring any of these new products or ideas to those companies. He's going to go form new companies and put them in it. So if you're a shareholder of Tesla and you're like, wait, we're not going to compensate Elon and pay through on what was agreed to, then maybe he's not going to do solar for homes really through Tesla. Maybe the next revolutionary thing that he wants to do, he's not going to do it in Tesla. He's going to go do it somewhere else. And so I think you kind of have to decide that. And I know some people might not like that and be like, well, that's not fair. Well, you don't have to own Tesla. Don't own it then. I mean, go buy some other company where you think there's a better deal. The problem is, what I don't like about it is all these shareholders 10x their money over this window. Like I said, if you had 100 grand, you were sitting at $1 million, and then they went and complained to the guy that they cut a deal with, in a sense, to say, nah, you shouldn't have got paid how much you got paid. I don't know. I kind of feel like if the board and the shareholders cut the deal, it was voted on, case closed. What else is left to talk about? And so, and I thought that was the point of why you should go to Delaware, is if those things are followed, you did the voting right, you held the things, that you should follow through on that. So that's kind of the thing. And I know I'll say that with Twitter and Elon Musk, and is that, a lot of people have just bailed on Twitter, or X, I should say, because they don't like some of the stuff he's doing. That's okay. I mean, if you had X stock and you're like, well, I don't like some of the things he's doing over there, go to invest in another company. I think that's how it should be. And that means he's going to have to prove himself on what he's trying to do and show real value there, which in the end for a company is showing profit and growth. So, all right, good question there. Sorry, that was political, Matt. He comes out a little bit here every once in a while. Or opinion, Matt. That wasn't political. That was just some opinions. Okay, let me hit a couple of things I want you to think about when you're setting up an LLC in a specific state. When you are thinking about what state should my LLC or corporation be in, I want you to think of these 5 things. There's 5 considerations I want on your mind. First, tax. What do you think about the tax situation? Second, liability. What liability issues and protections do I get in that state by having an entity there? 3, cost. What's the cost of that state or the cost of the structure that I'm going to be setting up? 4, what privacy considerations do I have? Privacy is separate from liability. Privacy is a whole thing in of itself that's separate from asset protection or liability. And then 5, you need to be thinking about the administrative burden of the entity. What I mean by that is how expensive, how many forms and things do I need to fill out every year or even in the first year to get it set up? There's an administrative burden to setting up and maintaining entities, and some states are worse than others. So those are the 5 considerations. What are the tax ramifications? What liability protections do I get? What is the cost of that? What privacy protections do I have? And what is the administrative burden of that state? Think of those 5 things when you're picking the state to set up your entity. Now, here's the quick answer on what state you should choose to set up the entity. There is no quick answer. There's no shortcut. It depends on your situation. And I know that frustrates people, but that's the reality of it. If you want the most optimal structure and the most optimal entity setup with the right state, it's going to be very nuanced and specific to optimize your situation. I don't think Wyoming is the place that everyone should be going to set up your LLCs. I don't go there for my situation. I know a lot of clients that make sense for their situation, but it just depends. So we're going to talk through this. And my goal by the end of the live today is you're going to have an understanding of what state you're going to be setting up entities in the future or moving entities if you need to make some adjustments here for your setup. Okay, let's go through uh, these considerations. And I want to use Wyoming as the case example here because there's a lot of questions already in on this. For example, Living Like a Winner asks, is Wyoming good for privacy? I don't want my name on public records. How do I keep private? Do I list a registered agent rather than myself? All right. Also, Roshan the foodie asks, what about setting up in Wyoming, a Wyoming LLC, and then doing a foreign filing into the state you do business in? Okay, that's a possibility. You could go that route too, possibly. All right, let's get into Wyoming and why. Let's go through these 5 factors on setting up an entity. Let's say it's a rental property. Let's just keep it simple. It's a rental property, and let's just say it's in Kansas City, Missouri. All right. Now, option 1, and this is my default as a lawyer, is set up the LLC in the state you own the property. Just go set up the LLC in Missouri. You don't need to go set it up in Wyoming. Why do I like Missouri? For taxes, there's no difference. Okay. We're not doing corporate tax structuring here. There's no S corporation. California has some nuanced tax issues because they have franchise tax and gross receipts tax for LLCs. But for most states, taxes are going to be pretty neutral. Frankly, you're taxed on the state where the income is made. So if I set up a Wyoming LLC, let's say, and I have a Missouri property, a rental in Kansas City, Missouri, the state of Missouri could care less about where that LLC is set up. They're still going to tax the income made on that property in their state. Even if I live in Arizona, they don't care. You make money in our state, you're going to pay income tax in our state, whether that's corporate or flow through income tax or on the rental property, the rental income, or the gain when you sell it. So tax is somewhat neutral, particularly for rental properties. Again, California being the kind of the nuance here and kind of the outlier, so to speak. Liability. Let's go ahead and share this whiteboard, Tristan. I just want to go through this so people can see the whiteboard structure on how asset protection works. So here you see, this is kind of our basic trifecta we've always been doing for clients for over 10 years now, where we set up your operating businesses on the left side. In this case, let's say that this individual has an S corporation. On the right side, we have your assets. Now, in this case, I show an LLC that owns a rental property. That's a rental property up there. Now, let's say something happens on the rental property, and we did a Missouri LLC for the Missouri rental property. Well, the tenant slips and falls. Okay. Now, the first type of liability protection I want from an LLC or corporation is I want to force that plaintiff, the tenant, the customer, whoever it may be, to sue the LLC. I don't want them to come down and sue me. The whole purpose of the LLC is limited liability. That's the L&L in LLC. So they're going to be forced to sue the LLC. They can get at what the LLC owns, but they can't come down and get at what I personally own. That is the first type of liability protection, and that is called the corporate veil. It prevents business liabilities from causing personal asset risk. So in other words, if something happens in the business, it stays in the business. It doesn't come down to the owner individually. You can't get at the personal assets of the individual. You can't get their bank account, their home, their retirement accounts. You can't garnish their wages. Can't get into their other entities or other assets. You're contained in that LLC or corporation where the liability arose. Now here, the LLC has a rental property so that there might be some equity in the home at risk if they did sue the LLC. Maybe there's a little bit of cash in the bank account. As a general rule of thumb, we don't want to keep investment income or kind of like a large sum of money in LLCs or corporations where they have liability assets like a rental property. You want to leave enough money in there to pay the bills and operate it. But if you have cash flow generated in there, we want that money to go into other investment accounts or into separate LLCs that don't hold liability producing assets like a rental property. All right. So now that corporate veil protection I talked about, where they're forced to sue the LLC, they can't sue the owner. That is the same in all 50 states. You will get that for LLCs and corporations in all 50 states. There is zero distinction. So in this instance here, if I'm really concerned about something being done in the business, whether this is an S Corp that's an operating business with customers or a supplier that I have a lawsuit, they're stuck there too. Where this is an LLC with a rental property and tenant slips and falls, they're stuck at the business. That corporate veil where they're stopped to come down to you personally as the owner is the same in all 50 states. So I'm not going to go look at some other state for that. I'm going to look at the state where I'm going to be operating the business, or in this case, with the rental property example, the state where the rental property is located. So my default is going to be, I want to do a Missouri LLC. Now, here's where the Wyoming LLC comes in. This is the first consideration of why you might want to do Wyoming. And let's keep on the diagram here if it's still up, because I just want to show there's another type of liability that can occur. And this could affect your LLC. Let's say you end up owning 10 rental properties and you've got $5 million of net worth between those rental properties. You've paid down the debt. There's been appreciation. You've got good equity in these properties. Maybe it's an apartment building or some commercial property. You've got a good amount of equity. And you're like, hey, if I get in a personal lawsuit, I'm texting and driving, I get in an accident, something exceeds my insurance, I default on some personal business stuff or I guaranteed it, I got just sued personally, and someone gets a judgment against me personally, let's say Matt Sorensen in this example. Well, what can that plaintiff do? They can collect against my assets. But for wealthier people, they typically hold a lot of their assets in entities. Now, one of the things they can do, that plaintiff, that creditor that gets a judgment against Matt Sorensen, in the example here, theoretical, is they could go after my assets, my home, any assets in my personal name. But if I hold a significant portion of my assets in a Wyoming LLC, what happens is the plaintiff is stuck outside the LLC. This is called a charging order protection entity. See, in this scenario, what I'm trying to do is I'm protecting my business assets from my personal liabilities. Now, in states like Missouri, Arizona, Florida, most states, frankly, if there's a liability against you personally and you own a company 100%, they can blow right through the LLC and force you to sell the properties to go satisfy the judgment. So they can basically foreclose, is what it's called, on the LLC interest and get right into the LLC, force you to sell the assets, and they get their judgment paid. However, in Wyoming, you get what's called a charging order protection entity, or a COPE is what we call it. They can sue the LLC, but they can't force you to sell assets. They sit outside that Wyoming LLC waiting for you to distribute money, but they can't force you to do it. So you can just leave everything up there in the LLC. Now, you can't have personal use of the assets or use those to cover personal expenses. You're going to have to distribute them from the LLC. And so that judgment would capture that money there. But it does put you in a position of control where the creditor is left waiting for you to decide when to send money out of that to cover their judgment. Because of that, it puts you in a strong negotiating position with that creditor to try and negotiate something in terms of a discounted settlement, perhaps, or maybe they sit out the side of there forever and eventually go away. I don't know, but this is the charging order protection entity. This is reason number one, and there's two reasons, but this is reason number one, people will use a Wyoming LLC. Now, here's why I don't like doing that for every person. If you're a small business owner making a couple $100,000 a year in your small business net, don't bother with Wyoming. You're not holding assets in there. You're not holding appreciated value. The business, operating business, is just receiving the income, covering the expenses, and sending the profit down to you. Maybe you keep some operating capital in the business. Maybe you have some equipment or inventory of value, but no creditor is going to go after that. They don't want that. They want cash or hard assets that they could sell easily, like real property. Now, on the rental property side, if you have 10 rental properties with $10,000 of equity in the LLC, a creditor doesn't want that either. They're going to have to sell all those properties to make $100,000. They're going to go through 10 foreclosures and 4 sales to get that collected. They don't want that. So in that scenario, you don't need the charging order protection entity. So what we generally do as a rule of thumb when we're choosing Wyoming is if you think you're going to have $1 million or more of assets, this is equity, valuable assets that could be sold. Think of, it could be 3 rental properties that have $500,000 of equity. It could be 1 commercial property or multifamily property that has over $1 million of equity. That's when we think the charging order protection entity makes sense and why it would make sense to use Wyoming. Another reason why it may make sense to use Wyoming, and this is on the liability front. Maybe you're someone that just gets sued a lot. Like you're a contractor that gets sued a lot. You're a plastic surgeon that seems to get sued a lot. You're just in a high liability industry. Okay. You have a bungee jumping school. I don't know, like in that scenario, you might want to do the Wyoming LLC too, even at a lower risk. Maybe it's 500,000 of value of assets in there of equity net worth, let's say in the entity, because you just have a higher risk profile. So we want to look at those two things really. How much assets do you have to protect? Is it worth it doing Wyoming? Versus also how much liability do you have in your personal life where you might run into a lawsuit? Have you been sued often personally? Are you in a profession or a business where it's common and that can happen? In that case, the Wyoming LLC makes a lot more sense because of that charging order protection that you get. All right. Okay. Now, Veronica asks, is the diagram describing a holding company in a Wyoming LLC? No, it's not. And that is a great question here. Let me show you how the holding company would look and actually how I would do it in that example. So if we were going to do a holding company strategy for Wyoming, this is what we do. That says Wyoming. Let's say this is Missouri. Oops. This is Missouri LLC. So that's MO, pretty sure. All right. So I'm doing this with my finger, guys. Okay. In the holding company strategy, Veronica, what you're doing is you would own the Wyoming LLC here, which is the holding company. That Wyoming LLC owns the property LLC. In this case, the property is in Missouri, which is the Missouri LLC. And that Missouri LLC owns the property. So now if something happened, tenant slips and falls, they have to sue the Missouri LLC. They're stuck here. The tenant can't get anywhere. So they can get at what the LLC has again, but they can't get down to the Wyoming entity. They can't get down to you personally. Let's say you get a judgment against you personally. Where can they go? They can go sue the Wyoming LLC, but they're stuck there. They can't get up they can't even get into the Wyoming LLC. Actually, they get stuck outside of that. They get stuck right here. So that's the holding company strategy. That is a good strategy. We use that quite a bit, particularly for real estate investors that have a lot of assets or growing a portfolio. Um, Using that holding company works. And then, you might have 10 property LLCs up here for 15 different properties. So that holding company strategy, that's how it worked there if you were going to do Wyoming. Great question. All right, okay. I'm still on reason number 2 on why you would do an entity that was liability. Now let's move on to cost. We want to look at what does it cost to set up the entity. There are states that used to be very popular that are actually very costly when it comes to setup and maintenance of the entity. Nevada was a state that used to be 10 years ago very popular for people to go and set up entities. The problem with Nevada is they use it as a source of revenue. They made up this thing called a master business license that every entity needed to have in Nevada, even if it didn't even do business in Nevada. So many people had Nevada LLCs or corporations and were doing business in another state. Well, Nevada's like, we don't care. You need to send us $500 a year. And so they had this master business license that became very expensive year to year. Another state that's very costly is California. California has an $800 annual fee for a corporation or LLC. That's the minimum fee. Even if the company loses money, you got to pay a minimum $800 to have an entity in California. Now, because of those issues, we generally do not like Nevada unless you're doing business in Nevada because it's a costly state. It's more expensive. Most states are like $50, $100, $25. Arizona, my state, is zero annual fee for LLCs. Some states are like $10. So there's a range there, and I would say the average is between $50 to $100 on an annual fee to your state. But you're gonna get some states that are more expensive: Massachusetts, Illinois, even Texas has got pretty expensive. It's a few $100 in Texas too, in terms of filing fees and renewals. So you want to be careful on the cost. Now, California, I know there's 30 million plus of you, and you're like $800 a year to have a corporation or LLC in my state. Pass. You don't have a choice. If you're doing business in California, whether you're an operating business, you're selling goods or services, or it's a rental property there that's in the actual physical state of California, you have to do a California LLC or corporation. You just don't even have a choice. Okay. Even if you set up the entity in Wyoming and you're doing business in California, you don't even register it until California you're doing it. California is going to still make you pay the 800 bucks. Okay. California does not care. Even if it's, and this is in the Franchise Tax Board guidance on LLCs. It says, if you, and it gives this example, seriously, this is in the Franchise Tax Board guide. It says, if you're a California resident and you set up a Missouri LLC, and I used Missouri earlier because of this example. They said you set up a Missouri LLC and it's a Missouri rental property, and you have a property manager in Missouri that manages the property, but you make a phone call from California to talk to the property manager, or you send an email communicating with the property manager or a tenant about the rental property in Missouri, but you live in California. That company, your LLC or corporation, just did business in the state of California, and you have to pay the 800 bucks. So if you live there, it's essentially impossible to get out of it. Maybe you have someone else as the manager that handles everything and you're not involved at all. You're really just the owner. You don't make the phone calls. You don't do the emails. You're just not involved in the business operations. It's possible in terms of the Franchise Tax Board guidance, you could be in the clear there. But for the most part, most of our clients, business owners or real estate investors, they're going to be involved at least a little bit, even if they have a property manager, to know what the heck's going on and to check on things. And so because of that, California is going to make you pay this $800 franchise tax. So what we would say in that example, let's say you did own the Missouri property with the Missouri rental property. I would just do a Missouri LLC. You actually don't need to register in California, but in terms of the Franchise Tax Board, in their opinion, you owe them 800 bucks a year. Like you could be, and because that conducting business is just such a small definition. A phone call to a property manager, just because I'm in California, make the phone call, I was doing business in the state of California, even though it's a Missouri property, the Missouri property manager. Like if you're sitting on the toilet thinking about your rental property in Missouri and you're in California, you just did business in California too, and you're going to owe that 800 bucks. Okay. So be careful on avoiding California. Really California residents, the only way to get out of that is to leave California. I'm sorry. You can play games, but the only clear way you'll really be free of it is to leave California. Okay. And I know there's lots of considerations of why you wouldn't do that, but I'm just saying if you want to get out of that clean, you just got to leave the state. Now, for those business operators in California, you're selling goods or services, you're running a business for the last 10, 15 years. So many of them thought, I'll just go to Nevada. It's right next door. I'll set up a Nevada LLC or a Nevada corporation and I'll just go do business in California. That doesn't work either. Okay. Because California is going to say, oh, but you're doing business in California? You're selling goods or services in California? You need to register that Nevada corporation or LLC into California. That's what's called a foreign filing. So once you do that, now you're on the radar of California anyways. You're paying California fees and you're paying Nevada fees, which aren't cheap either. So just skip the Nevada and just go right to setting up the entity in California. All right. Okay. Now that was a cost discussion there. Generally, the cost is not an issue in most states, but California has that issue because of the $800 franchise tax. Again, avoid Nevada. It is expensive. Delaware's a few $100 a year in renewals. Another reason to avoid Delaware, not just Elon Musk's reasons. So I kind of go back to our rule of thumb is set up the entity in the state where you're conducting business or where you actually own the property for you real estate investors. Now, you can do the Wyoming holding company structure like I showed a moment ago. That makes sense, particularly for people building a real estate portfolio where they're wanting to protect assets from their personal liabilities. I get that. And that's where we use it too, is in our law firm at KKOS Lawyers. So I'm not saying don't use Wyoming. I'm just saying it's not for everybody. It's kind of a nuanced situation where I'll use it. There's one other reason you'll use it here in a second, which I'll get to. Okay. The fourth consideration on what state to set up your entity is privacy. A lot of people want to be private in their business. Now, some people are like, I'm running the business. I'm on the website as the owner and CEO. Everybody I go talk to knows this is me, my entity or my operating business. I don't really care about that. And frankly, that's me. I mean, in my businesses, I'm all over it and my name's on it. And I got some real estate investments and LLCs that I would prefer to be a little more private. And we'll get to that on how to do that. So for most people, when we're talking about privacy, we're talking about your asset holding entities. I'm not talking about your day-to-day business where everyone knows you own it and your name's on the website and on the business cards and all the marketing collateral. I'm talking about your asset holding entities Maybe it's an LLC that owns brokerage accounts or other liquid investments. Maybe it's LLCs owning rental properties, or other forms of real estate or hard assets. And you want some privacy to that. You don't want to own an apartment building where 50 tenants know your name. You'd rather they know the property manager and that's it. You don't want that on the public records for them to come knocking on your door because you had to evict them and they say, we need a place to stay. You evict us from our house, So, and I've seriously had that happen to a client before. So, what you can do in terms of privacy, you can use the Wyoming structure here. And Wyoming is a state that provides pretty strong privacy. When you file an entity with a state, most states are going to require you to list a member, a manager, and a registered agent, sometimes a statutory agent. Those are three names, people's names. And sometimes you can use a company that are filed on the document with the state. Now, we always recommend clients do manager managed LLCs. The reason we like manager managed LLCs is you just list the manager. Now, this could be you, and most of the time it's the owner of the business, but no one knows that. It doesn't say you're the owner. Your just name is there as the manager of the corporation, or excuse me, in the LLC in this instance. But if you did a member managed LLC and you listed yourself as the member, well, member means owner. You just told everyone you own this thing. So the first privacy consideration is make sure when you're filing it, do manager managed. Now, every state has manager managed LLCs. So you're going to get that form of privacy where you only have to list the manager and you don't disclose the owners. Now, there are a few states, even Arizona, my home state, where 25% of our owners have to be listed. And so your name could get on that. You could use a shell company or some type of entity below it where you have some privacy. Sometimes we use that for higher net worth clients where we use a Wyoming LLC to provide some privacy, because there we can just list the LLC as a 25% or more owner. We don't have to list the individual. All right. Another consideration on privacy is the registered agent. Registered agent, every corporation or LLC has to have what's called a registered agent. There's some states that call it statutory agent. This is the person who receives the lawsuits if the company's ever sued. You have to list a person or a company that has a physical address in the state where the company is set up. So, for example, in Arizona, you have to list an Arizona person or an Arizona company at a physical address in Arizona, not a PO box, where notices, service of process, lawsuits can be served. Now, if you set up the LLC or corporation in the state where you reside, a lot of people are like, I'll just be my own registered agent. I'll just list my personal address. You can do that. Your personal address is going to be listed on the corporation website. You can get process servers at your home serving you legal notices. You may not want that. And so some people are like, let me just use a registered agent company. Now, we have a registered agent company. Our company, Main Street Business Services, does registered agent services for thousands of clients across all 50 states. We manage 10,000 plus clients with their company compliance. That's mainstreetbusiness.com. But in that instance, Main Street Business Services is listed as registered agent at our address, and we have addresses and relationships in all 50 states to receive those notices and service of process. So you can just use a registered agent company. All right. Now you're going to pay 125 to 200 bucks a year for that service to have that address listed for them to receive any notices. They forward them on to you if they get them. But that provides an additional layer of privacy. So again, if you're someone that's like, privacy is important to me, you should definitely use a registered agent service. All right. You definitely should be using a registered agent services, whether it's ours or some other one. Now, in some instances, you don't have a choice. You have to list a registered agent company. All right. Let's say you're doing the Wyoming structure, the Wyoming holding company. Let's say you're doing the Missouri LLC for the Missouri rental property and you live in Arizona. Well, I have to have a registered agent in Wyoming for the Wyoming entity. I have to have a registered agent in Missouri for the Missouri entity that's at an address in Missouri. And for the Wyoming LLC, that's at address in Wyoming. So if you get a more elaborate structure, you have more registered agents because you don't live in Wyoming. You don't live in Missouri. So you can't just list your name and your home address there to receive the legal notices. You're going to have a registered agent company. This starts adding on costs. So privacy, you can have it. It's not perfect. You can give yourself a little more privacy, but there's always a cost to it. There will always be a cost to the additional layer of privacy. All right. Now, the next thing you can do in terms of privacy is you can use a Wyoming entity. This is another reason why people use Wyoming. I told you there's two reasons people use Wyoming. This isn't about Wyoming entities, but they just get used in some of these instances. So reason number one, remember, was liability, charging order protection. If something happens to me personally where I get sued, they can't get up into my LLCs that owns my rentals or other assets. They're stuck down at me personally, and I get that charging order protection that prevents them from getting in and forcing the sale of my assets or properties. That was reason number one, to use a Wyoming LLC. Reason number two, privacy. I like to use the Wyoming LLC for clients to have investment accounts, brokerage accounts, other liquid assets where it doesn't really matter where they're at. They just want an entity, but they want some privacy to it. They don't want someone to pull up state websites and find all the entities that they own. They don't want to see their name on it. They don't want to see their name even as a manager, incorporator, organizer, registered agent. They don't want to see their name anywhere. This is where Wyoming is used for privacy. In Wyoming, when you establish an LLC, you don't have to list the manager. You don't have to list the member. You only have to list the organizer. When you renew it, you can have an authorized person sign as an authorized person, which we do in our company, Main Street Business Services, where we file as an authorized person to renew your entity. That's another exposure area where you want to make sure this privacy continues on. And so Wyoming provides an additional layer of privacy because it doesn't require a manager or a member to be listed, and you can have someone else be the organizer. Most law firms that are sophisticated will serve as organizer for their client in Wyoming. Most of them charge an additional fee for that because their name gets listed on the documents rather than yours. Sometimes that requires some extra work, plus a little bit of liability and issues, particularly if you're doing some weird stuff with your company. And so there's going to be a fee for that where you're going to pay a little more. Now, Wyoming is used for privacy there, and sometimes people use the Wyoming LLC not just for like investment accounts or brokerage accounts, let's say, but they'll use that Wyoming LLC where no one knows who owns it to be the manager of their other LLCs, where you're required in other states to list the manager. So, for example, here in Missouri, let's go back to the diagram. Let's say you have that Wyoming LLC that's the holding company. You could use that Wyoming LLC or maybe a separate one to be the manager of the Missouri LLC. Missouri makes you list a manager when you do a manager managed LLC. You don't want your name there as manager personally, even though you get liability protection. You want to list another company. Well, you list the Wyoming entity. Then if someone looks up the Missouri LLC and sees a Wyoming LLC as the manager, then they go to the Wyoming website to see who owns that. You can't tell either. So in some instances, not every state that strategy works, but you can get a little more privacy protection by using the Wyoming LLC as the manager on other entities as well. All right, let's unshare that if it's stuck. Okay. Oh, okay. I got to catch up on the questions here. Sorry, guys. Got on a little rant there. Okay, let me get to some of the questions here, and then we're kind of get to the fire round here. We'll be wrapping up in the next 10 minutes. All right. Tolase on Instagram asked, does it make sense to open an LLC if both my wife and I are working as a sole prop, making less than 40K in revenues? She's a balloon artist and I'm a tax advisor. I think it does, particularly if you have an intent to grow the revenue from those businesses and that income. Now, the caveat here is, are you in California? If you're in California, I may say, let's wait a little bit, maybe. But I think an LLC at 40,000 in revenue makes sense. I don't know what your net take home is on that. But I do like that you have 40K of income. You both have different services. You can do both of those services through the same LLC, pick a generic name. You could have DBAs or trade names for the different things. If the balloon artist business has a different name than the tax advisory business, obviously, which I would presume would be the case. So you could have one LLC that but effectively works for both businesses, but have different trade names or DBAs that you can use legally in describing those businesses that are tied to the LLC. So I like it. The reason I would do the LLC is as the income grows, once you're at 40,000 of net income from an operating business, which a balloon artist or a tax advisor would be net operating income. I mean, that's operational income from selling goods or services. We want to add an S selection to the LLC so that it turns into an S corporation for tax purposes. That's for another live and another day. And I've got lots of videos on that. Mark, my partner, and I cover that in our podcast all the time. The S corporation is the number one entity structure, whether it's a S corporation or an LLC taxed as an S corporation. It is the number one entity structure for small business owners making 40,000 or more net income. Okay, I want to emphasize net income, not revenue. Once you're at that net income level, using an S corporation or an LLC tax as an S corporation will save you thousands of dollars every year in taxes over just being a sole proprietor or an LLC that's just taxed as a disregarded entity, sole proprietor. So, but doing the LLC now gives you some legitimacy. It gets you some asset protection if something happened in one of those businesses, and also gives you the ability to add the S election to it later when the tax benefits are there and you have at least 40,000 in net income. Now, again, if you're in California, there's an $800 annual fee to that, so it's a little more expensive. You might want to wait till 50K of net income or something like that. So, oh, he's in New York. He says, okay, all right. Oof, New York's a little bit of a caveat too, because if you're in the 5 boroughs area in New York, you actually cannot do an S corporation. So I would be careful. I'd be careful doing the LLC strategy. So what I would say, to let's say in New York, it's a little nuanced, but I would still look at doing the LLC for the asset protection benefits, and just establishing those businesses for the long haul. I presume there's an intent to grow those businesses. If you're like, no, this is just a side hustle. We have other careers, other businesses. These are just side hustle stuff. Then I probably wouldn't. I don't think those are liability producing businesses. You can keep doing those without it. But if your intent's to grow them, I would get the LLC now. It'll make sense to have it set up now. It'll be structured right moving forward. The value of it will be more important. All right. Okay, Pace Morby says, "Sup, handsome." I think Pace does like my beard. I kind of stole it from him a little bit. It's a little short today, but I appreciate that, Pace. Um, all right, let's see. We got Tamuchi from YouTube asked, "Would you need to hold a mortgage note investment in an LLC or in a self-directed IRA?" No, you don't have to. A mortgage note investment is, again, this is a debt instrument. Basically, you lend someone money and they agree to pay you back interest and points. You're like the bank here. You're owed all the money. And so you might have a mortgage or a lien on the property, and some other borrower, maybe it's a real estate investor or small business owner, they owe you money back on it. Now, I do this myself with my own investing. I do that. I actually do use an LLC in my instance, but you don't have to. I use the LLC because that LLC does other investments and I like keeping those investments in the LLC. But it is lending out money from the LLC and it's going back into the LLC. And I do short term loans, usually 6 to 12 months. Then when they come back in, I just had one come back in 10 days ago. It goes right back out on the next deal, which it did within a couple of days. And so you could do the LLC, but it's not necessary. For those of the self-directed IRA, which by the way is an IRA or 401k that can invest in real estate, it can lend other people in real estate, it can invest in a private fund or a small business. These are IRA or 401k accounts that you don't just buy stocks or mutual funds with. You could, but the self-directed IRA is usually used by people doing real estate deals, private funds, private investments, private equity, lending money like this with a mortgage note. You can do that right out of the IRA. You don't need an LLC for that. If you're doing a lot of them, the LLC is more convenient just because you have a bank account for the LLC and it's easier to get the money in and out of the LLC. But if you're just doing one loan from the IRA, not necessary to the LLC. You could, but one loan out of the IRA directly is pretty easy to pull off. And in that instance, of course, the lender on the note would be the IRA, Directed Trust Company, FBO, Tamuchi's IRA. If you did the loan from the LLC, the lender on the note would be, XYZ Investments LLC or whatever you decide to call your LLC. All right. Okay. Veronica asks, I have a registered agent to my holding company, but when I registered in California, my name is on the statement of information. How can I make it so my name won't show up on the website? Ooh, great question. I've mentioned a couple of times, there's always a California caveat. This is another one. Okay. In California, you have to list officers and directors on what's called a statement of information. For an LLC, this would include anyone who's a manager. Now, what you could possibly do, and I don't know who the manager of this entity is, and I don't know that it works in California. I just want to confirm this with one of the lawyers in the law firm. I don't know if you've worked with our law firm or another one, but you might want to check this. Could I just list my Wyoming LLC as the manager? And some of our bigger clients, they'll have their Wyoming holding company LLC that, let's say, owns the Missouri LLC or the California LLC here. And they'll have a separate management entity in Wyoming for privacy purposes that's the manager on all the other entities. They don't use the holding company for that. You could, but they end up using a separate management entity because they just like to keep the management separate from the holding. Um, I don't know that there's a huge reason to do that. It just makes sense from separating for organizational purposes. Believes a management Wyoming LLC to be the manager of the California entity, and that LLC's name is on the statement of information. Now, I don't know. A lot of people say that you have to then list the manager of that entity for signing purposes, and then you are typically the manager of the Wyoming entity, even though Wyoming didn't make you list that there, but on the California form, it's being forced on you. So not every state is perfect on this. And California is unique in a statement of information. There's not there, I can't even think of another state that has something like that for LLCs, actually. That's a unique form that California came up with to charge you another $50. And she listed herself as the manager. So the only thing, Veronica, I would look at is using maybe a Wyoming LLC for privacy protection purposes. If you have the holding company structure already, you could maybe look at using that entity, or do a management LLC in Wyoming that just is the LLC you used to be the manager on your other companies. So I'd look into that. And I would say, if privacy is important to you, it seems like it is for Veronica. Some of you listening are like, I could care less about privacy. Okay, let me get to the fifth reason here, because I want to go through tax considerations, liability considerations, cost, privacy, and now we're at number 5, administrative burden. Some states are really easy. LLCs in Arizona, once you file it, there's no annual fee and no annual filing. There's 2 things that come into account when you set up an LLC and you're looking at what state. If you think of the ongoing maintenance that I got to do to keep it active and keep it in good standing, there's really 2 things it boils down to. What do they charge me every year? And what do I have to file every year? Let me run through a couple of states that are popular just so you know what you're getting into. Arizona's awesome. No annual fee, no annual filing for LLCs. Now, corporations do have an annual fee and a filing. It's like $50 in Arizona. California, I've already mentioned it. You have a franchise tax board filing. You have to file a franchise tax form. You have to pay an $800 minimum fee. California's on the high end in terms of administrative burden. Now let's go over to Texas. Elon Musk went to Texas. A lot of people love Texas. Well, guess what? For you, any of you people using LLCs, many of you real estate investors that have bought properties in Texas, or any of you doing business in Texas, the 20 million plus people there, Texas on LLCs has a franchise tax too. Okay. The nice thing about Texas, there's a pro and a con to their franchise tax. The pro on the franchise tax in Texas is there's a small business exemption that you don't have to pay it if you're under 1.1 million or 1.2 million in revenue. It was 1 million when they first did it, and it's been adjusted for inflation, but so it's a little over 1 million in gross revenue. There's 0 fee you have to pay, but you still have to file something, and you still have to say you're under the exemption, or your entity goes into it's not in good standing anymore. It goes into like administrative, you're like not in a good status with the state of Texas. So that's what the Texas State Comptroller's Office, where you file that. So Texas is kind of a pain because you have to renew it and you got to pay an annual fee, and you're doing this franchise tax filing. Now, again, if you're under the $1 million of revenue for the year, you don't pay them anything anyways. So it's not a big cost, but it is something that's administrative burden you'll have to file. And that one sometimes catches people off guard. There's some states that are wonky, like Florida, where your LLC files every other year. They don't want to hear from you every year. It's just every other year. And could you remember that and how to do that? Now, our company, Main Street Business Services, mainstreetbusiness.com, you can go to. We do this maintenance for clients to keep it active. We track, does it need to be filed? We file the filing fee and the form you need to file in your particular state to keep it active. A lot of people like to use a service like that, where someone else is doing that. They're doing the minutes even on it on an annual basis to make sure it's all done and taken care of, because your accountant or CPA doesn't do that. So you might want to use a third-party company. Ours is Main Street Business Services that we use. But so just make sure you understand what the annual filing is and what some of the annual fees and forms you're gonna have to do on an annual basis for the entity. All right, last topic I want to hit. Now, that was the 5 considerations. I've already summarized them here a couple times. We're getting towards the end here. If there's any lingering questions here, we're wrapping up here in the last couple minutes. But I want to say, what do you do if you need to move the entity from one state to another? What if you're like Elon Musk and you're like, Delaware sucks? I finally came to realize that, and I'm going to go to Texas. Well, what he did in that situation was he did what's called articles of conversion. That's what Texas has. So when you decide the state you want to move the entity to, You file what's called articles of conversion. The corporation or LLC stays the same. Your bank account stays the same. Your tax ID stays the same. All your contracts and relationships and vendors and all that can stay the same. But the jurisdiction of the LLC is going to change. This is done through articles of conversion if in Texas in particular. Sometimes it's called articles of domestication. They mean the same thing in a sense. Some states have just adopted different procedures and names for it. Now, the end outcome of that is, let's just go to Elon's case. Tesla is now a Texas corporation and they will be dissolved in Delaware. We've had a lot of clients move from California. Over the last 5 or 6 years, we've had a lot of our small business clients, even real estate investors leave California, but they've had California entities and California businesses, but those businesses have moved with them too. Let's say they're now in Idaho, okay, or they're in Utah, or they're in some other state. Well, we are going to do articles of domestication, domesticating that into the new state, let's say in Idaho, and now they're an Idaho LLC or Idaho Corporation. And then you go back and dissolve the California entity. You want to stop the annual fees, the annual $800 in California, and close it out. Now you really got to move. Okay. You're not moving an entity out of California if you're still doing business there or you own property there. Okay. We're talking about you moved the business or you've gone to another state or you set it up in California. You had no reason you needed to do that. Or you're in just like Delaware or some state. You're like, why did I go there? I'm in Nevada. What the heck was I thinking? You know, I talked to a client a few weeks ago that has a operating business in Florida, and someone had told him to set up a Nevada entity. Why? Florida's not that bad, you know. Just do the Florida entity for your Florida business, and so you could do articles of domestication in that scenario. All right. Okay, we had a question popping in right now on YouTube, and we're gonna finish with this one. As we get to these questions, I just want to let people know, make sure you subscribe to the channel on YouTube. Make sure you join the private Facebook group. We're going to be coming back once a week. I'm taking next week off though. So we'll be back. I know it's not good. On March 11th and at least once a week on Mondays. We're going to be adding something in on Wednesdays too. But on March 11th, we'll be back talking about the backdoor Roth IRA. We're going Roth planning, Roth IRAs, Roth 401ks, why this is the #1 tax planning strategy for high income earners, using retirement accounts and building tax-free wealth. It's something I've been helping clients do. Again, we have 1.5 billion in assets at directed IRA. We have a backdoor Roth IRA structure. I just want to go over the strategy in general. It can get a little tricky and sometimes it sounds a little quirky, but we're going to go over how it actually works, get into the details, answer the questions, go beyond a Investopedia article on the topic so you know how to actually freaking pull this off. So look forward to backdoor Roth IRA on March 11th. Now, please get over to mattsorensen.com. I have a little Ask Matt button and ask your questions there. We want to get some audio questions as we're going live on YouTube more. I'm going to be doing some Q&A on there. I want to get your questions, answer them, try to give as much value and information out here as possible. I just love this topic of building wealth. I was a broke teen kid. I was a teen dad. I was a dad at 18 and I was broke and I had to figure out how to make money. And I did it the old fashioned way. I put myself through school. I learned a valuable skill. I found an amazing partner and we grew a law firm together. I started a company directed IRA where I get to work with awesome people. We're an Inc. 5000 award winning business. I just figured out a lot of stuff along the process. Meanwhile, I happen to be a tax and business lawyer helping clients every day, getting into all the tax and business considerations, planning their estates, trying to figure out their finances, pay off their debt, helping clients use retirement accounts. What's the best retirement account to use? There's $35 billion in retirement accounts. It's where most people have built their long-term wealth in America. And I became an expert at that. I just got stuff I want to share and teach. And that's what we're going to be doing here at Team Wealth Building. So please make sure you're subscribed. Get to the private Facebook group. Ask your questions over at mattsorensen.com. There's a little Ask Matt button. I'd love to get some of those recorded. We'll play your audio if it looks good and it comes through good and it's applicable to the topic. And we'll be hitting your questions in the future open forums and the lives. All right, we got the last question here. We're going to close out on this. This was Joseph from YouTube. He says, if my residence is in Georgia, but I'm providing accounting services to clients in other states, can I operate with a Wyoming LLC only, or do I need a Georgia one as well? Well, you can do a Wyoming LLC, but you're going to need to register it into Georgia. If you're actually physically operating in Georgia, that Wyoming LLC will need to get foreign registered into Georgia. And that's fine. So what happens is The downside to that is you're paying fees in Wyoming and you're paying fees in Georgia. But frankly, you don't have a choice. What I would say is for an accounting services business, I wouldn't have done Wyoming in the first place. I only like Wyoming for holding entities. Remember that charging order protection I talked about? That's to protect the assets in the LLC. Here, if it's a business providing services, accounting services, I don't care what services are. You're a barber, you're a landscaper, you're cutting hair, you're cutting grass. I don't care what it is. Um, you're providing a service. You're not holding assets in the entity typically. You're holding operating cash. So the Wyoming LLC is really only a privacy play there, and I don't think it makes sense for an operating business where people know you're the guy providing the accounting services. So I would have just done from the beginning a Georgia LLC in your situation, Georgia, Joseph, but you could register the Wyoming LLC foreign into Georgia as well. The only downside of that is you're paying fees in two states. You might want to just cut the cord now, close down the Wyoming LLC, or maybe use that in the future for something else, maybe assets or other properties, and do a new Georgia LLC that's going to own your operating business, providing the accounting services, which as that entity grows, you might add an S selection to it if you're making more than 40 or 50,000 of income. So that LLC is taxes and S corp. So make sure that's on your radar too. All right. Well, that is our first live here with Team Wealth Building. Thanks everybody for being on. Thanks for all of you guys that asked the questions. Veronica, Joseph, Talase, David. Appreciate all your questions. Roshan, live like a winner. I appreciate all the questions. We will see you back here next time. And thanks for all of your questions that came in. And stay calm, self-direct on. Good luck in building your future. We hope to be a resource for you for many days to come.